Well, I can see we've run off Isabel already as she escapes for the door.
I'm getting water.
We're going to try and catch up here and run through a few of these slides quickly. But so Justice Brandeis, he was a justice on the Supreme Court of the United States. In law school, that wasn't the first I heard of him, though. What was the first I heard of him? He was famous for his, anybody know? His Brandeis brief. Does that ring a bell? Maybe, a little bit. So, and a lot of people credit this for having his profile elevated from the bench. He was a litigator out of Kentucky, and he came up with this idea of a Brandeis brief. He was the first person to rely on social science or on empirical data in a legal argument. So he came out of the realm of pure legal theory. He used it himself in Mueller v. Oregon, which was, I'm not a constitutional law scholar. I think this had something to do with conditions of workers, maybe for women. And he used a lot of social science and empirical data to try and push a case through to the Supreme Court. It was relied on in Brown v. Board of Education, which was the big civil rights case for educational rights. So why is this my lawyer's view of the CFSR and of some of the other materials we're going to walk through? Because I think a lot of the data that you can find on fosteringcourtimprovement.org/Georgia, there's your sales pitch, and a lot of the findings of the CFSR is ripe for use as evidence. It's ripe for use and relying on that and moving cases forward. And we'll see more of that as we walk through this. But I'm a bureaucrat. I sit in an office. I do a lot of data analysis and data training. But I've still got that legal degree chipping away at me in my mind. And so as I start to think about how to connect these two ideas, this is, for me, where the rubber hits the road. Using this information to improve individual case outcomes. So that's my lawyer's view of the CFSR. I'm going to hand it over to Andy. He's going to walk through a couple of slides on the CFSR.
Yeah, so this is a redo of that slide you saw earlier, but here I just want to point out that the way the CFSR was designed, and presumably it's a work in progress, so the federal government is going to probably put together some more committees and add some more measures to this, but right now as it stands, of the data measures that we have on the CFSR, we have 1 safety measure, 4 permanency measures, and 0 family support measures. And with that, you can certainly see how we could get some fairly unbalanced systems, where if we're not measuring family support at all, there's not a whole lot of incentive, especially with fines as large as some states like California, where are facing $20 million fines. They may be pushed into some practice areas where they would rather not go. So this is just to show that that you can get there in various different ways. Georgia is meeting the mark at this dashed blue line on the time to reunification, and largely Georgia is doing that through our reentry performance. We have a very low reentry rate. That's all, really, I think, on that. Now, here are examples of how this can go awry. If we start doing a lot more family support, we might be taking cases that would otherwise have come into foster care. Now, when we avoid foster care, and this was an argument that I think I used fairly successfully with some of the federal government people, when we avoid foster care, we're effectively doing a reunification time of 0. You could look at, if you took our rates for removal back in 2004 and added in all the children that, amongst those that we wouldn't remove today to foster care, and put them in as 0s for their reunification time, well, most of our children then in foster care get reunified in 0 months. So we're performing extremely well. You can't get any faster than that. If you look at it that way, then it makes a lot more sense that we're actually preserving permanency rather than interrupting it and then putting it back together. So family support could lead to the halving of removals, which we've done. We're down 53% or something. And it might also lead to longer reunification times, but then those may lead to a better quality permanency with a better transition and cut your reentry rate in half. So these practices are encompassed by this composite framework, but not to my satisfaction, I think. There should be some family support measures added into here too. Another example, this would be on Composite 4, and Composite 4 has to do with the placement stability. It's all placement stability. You can see where if you were managing your cases that were in long-term foster care a lot better, and maybe moving out the colder cases, as we're using the term, you might be moving out children who have had maybe fewer moves, who had, if you're transitioning them to, say, a subsidized guardianship, you might be taking children who have a strong permanent connection to a caregiver and transitioning them from in foster care to a subsidized guardianship that's outside of foster care. What you're doing is you're taking the children with stable placements out of the foster care pool, thereby increasing your placement instability as measured by the federal government. You're left with a lot of unstable placements. So here's an example of where you might be doing the right work, and sure, we want to work on the permanency for the children who are less stable. But the ones who have stable placements, and it's kind of the low-hanging fruit, we want to go after that and get them into some guardianships. So we've used the cold case process and the permanency roundtables to move a lot of children to guardianships. We're doing fewer of these 3-week reunifications. Those 3-week reunifications were really helping our placement stability because those children were very unlikely to have unstable placements. They were only in one placement for 3 weeks, and then they were right back out. It made it look like we had a very stable placement system, but that's really false. With our model, we're trying to work on less congregate care. The congregate care, this would be group homes and institutional placements, are usually more stable placements than across the board. Now there are exceptions to that. But if you want to reduce your congregate care, you're actually going to hurt your placement stability. And then implementing something like our SHINES computer system where we actually are able to track placements. Back in our first review, we found that our placement stability was around 94%, I think, by the data system. When we went out and did a file review on that, and when we checked the billing records on that, we were really at something like 70%. So we were missing 20%, 24% of the placement moves. So here's an example of where a poor data system, a poor quality data system, is making your performance look a lot better than it actually is. And that was true of a lot of states back then, and that's where we set the bar for placement stability. So the bar is set exceptionally high for placement stability because we had lousy data systems 10 years ago.
Can I say something about placement stability? And we're working really hard with our partners in the provider community on this issue. We meet monthly to talk about it. What we're beginning to realize is those children who have the most placements are also more likely to be maltreated in care. And now we're having providers step up to say, what else could we do? Should we be working on trauma-informed assessment? What does practice look like with children who've been traumatized as opposed to just children who have been maltreated? And those kinds of inquiries are happening now because we're looking at this data and beginning to ask those types of questions. I see a partner in the audience here who's working on exactly that, and we are using both the cold case files and the roundtables to look at specific children and asking ourselves, what else is possible for them? What do we need to create that we don't have now? And maybe during the question and answer we can talk about more specifically what are those kinds of approaches that we're doing today.
Yeah, I had something else I should have pointed out on this one before we move on, because we are going to come back to placement stability, and Christopher's going to handle a lot of that. But I did want to show you something about what this slide is. The green portion of these bars would be the children in care over 24 months. The yellow portion in care 12 to 24 months, and the red portion in care less than 12 months. So we obviously, if a child stays longer in foster care, we would expect to have more moves. So they do try and segment it into 3 groups. So the very long stays, and the medium stays, and the short stays. And what we see, like in DeKalb, is that for the children with the less than 12 months, they're doing very poorly in terms of their placement stability. It's a very small portion of the bar.
And there you really have to get to know your community. In DeKalb, these are mostly teenagers whose parents really cannot deal with them, and often law enforcement will choose to remove. And however they get returned within 72 hours, so the short length of stay is impacted by that. That is a practice in the community that we need to get together and improve.
Exactly, yeah. And when we use charts like this in individual court stakeholder meetings around the state, or Christopher does now, we can actually point to things like that, and DeKalb does have a particularly large population of teenagers coming into foster care, and that is probably what you're seeing there. Okay, so this is yet another comparison. This would be a comparison of Richmond County, Georgia, versus a region in a mystery state, all right? A state that I can't name because they're cowards.
We'll remind you this is being recorded.
Yeah, yes. Well, they don't know who they are. They don't know who they are either, the anonymous cowards. So they're out there, and they have a very different practice from Georgia's. And so what they do is, see, they have these great big tall bars here, right? They remove a lot of children and reunify them very, very quickly. And the things I would want to point out is for a statewide number here, see that the magnitude of their blue bar versus the magnitude of Georgia's blue bar. Very different in terms of, this is the reentry rate. Georgia's reentry rate being, this state's is 14% versus Georgia's, which was 4% then. That's how much of a difference it makes in CFSR scores. So they score a little bit higher, and this state is particularly high scoring. They're one of the states that will probably pass on all the data measures on the CFSR in this next round.
Andy, is it worth mentioning how you get the data to do this? I mean, are these the DFACS charts? Are these your charts? Are these the Fed's charts?
Oh, these are so I have duplicated what the federal government is doing in these calculations. I received the data from DFACS via the Office of the Child Advocate, an agreement that we have there. And in other states, I have data sharing agreements with the University of North Carolina and the University of Illinois through which they can send data to me. And I do all the processing that should be the equivalent of what the federal government does. Now, they don't look at the data this way. This is for communication to local stakeholder groups.
I think I bring that up because a lot of people say, well, when data starts to improve, are you cooking the books? It's a good question. It's a good question, and I think it's a great question because a high level of trust is necessary when we're looking at the numbers. We all learn that numbers can be manipulated. So I always appreciate when that question gets asked. And Andy, being an independent person, an independent professional, gets the raw data and he can assemble them in these types of ways.
Yeah, so I can tell you that I do a lot of checks on the data, particularly on that recurrence rate, that safety number, because it came down so dramatically. I don't know that I'm a particularly suspicious person, but I didn't trust it. I didn't trust it at all. So I did a lot of checks on that. And there are a lot of ways that I don't want to reveal that I can tell when the books are being cooked. I can't find any cooking of the books. And I guess I'll leave it at that. I've done a lot of checking, and it looks real to me.
So we're at our break, which we've already taken. We're going to try and jump through some information on Permanency Composite 3, Permanency Composite 4 here. And I think what will probably happen with Isabel and I here, and Andy as well, is that we'll chime in with some of our own perspectives and from our own profession, between the legal field, the social work field, about how we can improve and what our role is in our ownership of these two composites. As we talked about earlier, Permanency Composite 3 is about achieving permanency for children in foster care for long periods of time. We're looking at children. This composite is measuring how well we serve the children that are spending long periods of time in care. There's 3 different components to this measure, and we'll walk through each of them briefly. This is really targeting how well we're achieving permanency for children languishing in care. That's that first one. The technical definition is on there. The second one is really concerned with this idea of, are we creating legal orphans and not finding them permanency? So are we terminating the parental rights of these children and then discharging them to emancipation, to long-term foster care, eventually leaving the system without a legal permanent connection to an adult. Finally, the last one is really geared towards, are children growing up in foster care? Are they spending long periods of time in foster care and then again leaving the system at 18 without that permanent legal connection? We failed as a state Permanency Composite 3 at the 2007 CFSR. It was actually a very close. We were almost passing. If you had me, I've got this bleeding heart from my students, I probably would have passed you. But the feds were strict and they didn't pass us. And so you can see that here. 2007, right here, is when the actual CFSR happened. They looked at 2005 data. So the royal blue line is the long-term foster care measure, and we're just below the blue line here. We just barely failed. So they used the 2006 data and put us under a program improvement plan. How are we going to improve outcomes for long-term foster care, for children in long-term foster care? And there's two responses that our state had to that question that we want to talk about. I'm going to turn it over to Andy and Isabel to talk about the judicial response, which was the cold case project, and then the executive response, permanency roundtables, respectively.
So I believe Isabel came up with the cold case name. Is that correct? Michelle?
In one wild conversation.
So Isabel said it was too mean, but the judicial branch had no problem grasping onto that. And
no such concept of too mean in the judicial branch. So we've named this thing the Cold Case Project, and it's a little, I guess it's a little bit deceptive. People usually think that they characterize this as children in care over 24 months. That's the base we start from. So the first thing we looked at was children in care over 24 months. But what we're trying to do is really target this permanency composite that the feds have, and that has some nuances to it. So the second measure in there, measure 3.2, counts the number of legal orphans that age out of the system. That's something that I'll admit I had not looked at before, and it was that was not on my radar. When we got to the federal review and I saw where we were on that, I dug into it a little bit more and checked against some other states. And in 2006, we discharged 100 legal orphans through emancipation. That is a very big number relative to our foster care population, relative to our child population, and relative to other states. So that is some exceptionally poor performance on that measure, and that hurt us big time, as it should. These are cases that shouldn't happen. So we started from those. We started from the legal orphans who were being discharged to emancipation. And we started producing lists for judges and others. The judges, for the first time, were seeing some of these cases because a lot of these legal orphans aged out without a court hearing. They just moved out of the system. They were checked off as discharged in the DFACS records, and the court never heard about it. And so Judge Key, who's now president of the National Council, has taken this baton up and is starting a national project to look at the legal orphans who are aging out. And we've got a few states that we're targeting for that. Anyway, so back to the cold case files. So in order to find cases for attorney fellows that were situated with the Supreme Court to investigate, to go in and read the files on, I put together a predictive statistical model that would predict a negative outcome on this composite 3. And what it found was that largely these were children who were in institutional placements. They were all over 24 months. Institutional placements, they were older children, obviously, because they were getting close to emancipation. But the single strongest predictor of a cold case, which was fairly surprising, was the federal funding stream. If there was no federal funding stream, the children were much more likely to be a cold case. So we have all kinds of possible explanations for something like that. And in the statistical realm, we usually term that a proxy for something else. It could be a proxy for family income. It could be a proxy for funds that would be attached to the adoption funds, subsidies, subsidized guardianships. There are a lot of things that would flow from the lack of a federal funding stream on a child. There are a lot of explanations for it, but there are also a lot of... So I think the leading contender right now is that because we don't have adoption subsidy funds for these children, we may be having a harder time getting them out of foster care. So that was number one. Number two, I think, was the length of stay, if they've been in care a longer time. Which makes a lot of sense to a lot of people. But number three, I think, was the age of the parent. So older parents were more likely to have children in this cold case category.
At the time of removal, older parents? The parent's age was taken at the time of removal, or no?
It didn't. Yeah, it didn't matter. But yeah, at the I think it was at the time of removal. Yes, yes. So. Child's age wasn't that important. Child's race was not, it was not a significant indicator. There were a few other indicators. Placement stability was not a very strong indicator, which was surprising. I can't remember all the others. Do you? Oh, if they had both TPRs, if they were legal orphans, that was a strong indicator of a cold case as well. So the process was that I selected them based on this model. The model predicted at about 90% accuracy whether these children would exit, and this was judged from validation samples of children where we knew the outcome. So we could predict with 90% accuracy whether these children were going to exit in a negative manner as determined by this composite 3. And so we chose 500 of these cases and randomly assigned them to attorneys with the Georgia Supreme Court, and they went out and used a review instrument that went through a pretty rigorous process and reviewed these cases. And so we're now tracking the outcomes for those children to see if that makes any difference. And now the project has been picked up and funded by Casey Family Programs, and we're moving it now inside of DFACS and joining it to the roundtables, which Isabel's going to talk about.
The permanency roundtables arose out of a need to kickstart the caseworkers and the other practitioners' questions around what haven't we done? Why isn't this child moving to a forever family? Why are they stagnant in their movement towards exiting with a positive outcome? We found that a lot of that was mindset. In a sense, a giving up or an acceptance that this was good enough and they were safe, and therefore I had other things to tend to. The roundtable brings various professionals together. It is not a staffing. The child does not attend. The family does not attend. It is a professional roundtable where we ask ourselves, what have we done? What have we failed to do? What else might we try? And what would stand in the way? From these questions, what can we try, came a number of possibilities, some which policy would not facilitate. So out of the roundtables came what we called barrier busting, which was an immediate call, or sometimes that policy person who was endowed with the wand of make it happen, as long as it wasn't illegal or unethical. We got through a number of barriers in that way. We would be able to sign off on the policy waiver right there, and a lot of things started to happen. We were looking at some of the cases that were most difficult to get, and the roundtables have resulted in over 1,000 children reaching positive permanencies, many of them which had an aging out track. And so particularly for those children, this practice has been picked up by 20 other states, and the Harvard School of Innovations in Government has named it a bright idea. It has not received the Innovations Award in Harvard because the program hasn't been in existence long enough for them to have enough data over a period of time to ensure that it does work in that way, but it's heading in that track. So it is also funded by Casey. One of the things that CFSR does is attract other partners that have the same goals for children. And Casey has invested in Georgia, because of our progress, over $1 million, and that in no way speaks to other things they're doing, like the cold case file and other things. So it is attracting major attention from very big players that have similar goals.
And essentially, from a lot of this work, we've learned what at least I've grouped into 5 broad categories. And these broad categories are going to appear on the left-hand side. And there's a cold case report that summarizes that. I think it puts them into 10 categories. I grouped them into 5 broad categories. And on the right-hand side are going to be some of my thoughts. Now, we're running out of time, which is great, because some of these I'm sure most people will agree with. But I'll have the power of the mouse here, so I'll just breeze through them, and that'll be great. So I will ignore your questions. But the first one, the idea is, and this is really a back to basics idea, find relatives. We need to find relatives. And this was said much more eloquently in the cold case review, but from a lawyer's standpoint, from my standpoint, I think a lawyer could have a field day with that term. Define diligent. That screams cross-examination to me. Mm-hmm. And what we found in the cold case project, what we're finding around the state through file reviews, is that sometimes they're not even there. Well, that's really not hard to argue about diligence when they're not there. They're required, court-ordered, required to be filed within 30 days. And even when they are there, have a field day with that. Define diligent. Whether you're on MyFace or Spacebook or whatever those things are, these are all questions you can use on cross-examination. That's my humble opinion. Now, here's the fun one that I'll really rush through. The use of APLA. The idea was around the state, APLA is being used too much. Now, when I do these trainings around the state and I go meet with courts and I go meet with judges and community stakeholders, I run a list of their APLA permanency plans. Okay, I should say what APLA is. APLA is a permanency plan. We have to have a plan for all children in foster care. APLA stands for Another Planned Permanent Living Arrangement. And I hear that, and what this means, we used to call it emancipation. We used to call it long-term foster care. But when we get uncomfortable with things, we make up really complicated ways of saying the exact same thing. And so we started calling it APLA. That was federally legislation. That's their mandate to us. Call it APLA. I think Bush changed it to SOPLA, some other planned permanent living arrangement. I'm serious. I think that actually was in I think that was in Fostering Connections. Let's call it SOPLA. It's in like a footnote. Let's check me. I don't know. Try it. And I would hand these lists of their APLA cases. Who's in care with an APLA permanency plan? Who are we not trying to reunify? Who are we not trying to find an adoptive home for? Who are we not looking for a relative? Who has some other planned permanent living arrangement out there? And what I got every time I handed this file was they run up to me afterwards and they'd say, oh, well, this child here, I mean, I know why they're on this list. This child's on here because this child's on 4 medications, they've got behavioral issues, that's why they're on there. And I was in Louisville. I learned how to say it. I was in Louisville this last week, and I got to hear from Pat O'Brien, who's a social worker out of New York, and he's got this passion. I was saved by Pat O'Brien. He has this initiative to adopt teens. That's what his initiative is. Find a teen and adopt them. He walks you through this neat little metric where you put your hand on wherever you think you're most likely to help a teen, and then he makes you go through these things, and it's a magic trick, and no matter where you start, you end up on adopt a teen, and that's how you can help a child. So he's going through this, and he's talking about it at this conference, and I'm getting all excited, and I'm like jumping, and I'm dancing to his music, even though he's not even singing. I'm this crazy guy in the back of the room, and he says, when I went and met with the social worker, that social worker said to me, well, Johnny's got a lot of problems, and so, he's on 4 medications, so I don't think we can, that's why they're APLA. And Pat's response was, there's a home out there, there's a parent out there for Johnny. Well, Johnny's been moved a lot, he's got a lot of behavioral issues, and so on and so forth. And so I was really into it. I was like, all right, there's a home for Johnny, and I'm waiting for the end of this story. And Pat O'Brien said to me, well, you know what, I was finally convinced that there's not a home out there for Johnny. Like, all right. And then he put up this slide. And he drawn on Henry Ford's analogy here, which is really that, it comes down to that local management. So I'll leave it with that and move on quickly before anybody challenges me that Apple is not a synonym for failure. Another big lesson learned from this project was engage the youth, involve them in the process. I will do nothing more than say empowerment. That is our local statewide organization of former and current foster youth that advocate on behalf of system change. They're a wonderful organization, and that's what I would say about engaging the youth. Talk to empowerment, they'll come talk to you about what you can do. The other one is this idea of we need better independent living, planning and services. And another thing Pat O'Brien got me thinking about was what my own independent living story is. And I was discharged independent living when I was 18 years old. That was in my head, that's what happened. I graduated high school barely, and I decided that I was going to pursue rock stardom. Let me get through this quickly.
Awesome.
After 2 years of pursuing rock stardom and realizing that I wasn't going anywhere with that I moved out on my own. I got my own apartment. I was discharged in independent living. Wasn't going to let my parents tell me what to do. I decided to go to a small liberal arts school in New York. I got a scholarship to go there to play sports, and doing it on my own, discharged in independent living. After that, I went off to the University of North Texas grad school. Again, was funded to do some work there. One of my favorite things that I've done in my life is I got to travel to Russia on a research grant and do some research there. Again, all independent living, discharged on my own, funding it. Eventually move off to Spokane, Washington to attend Gonzaga University, and finally on to Atlanta, to where I've spent the last few years working here. And this was my independent living plan. And what I've realized the other day, and what Pat O'Brien got me talking about, is that I got a phone call from my mom about 3 months ago. And she said, my room is no longer available for use. It's sewing time. So my mom has transferred my room into a sewing room. It's all good. 30 years old, I no longer have that backup plan. And one of the things is, and I started to think about how often I lived in that room during this independent living discharge time of mine. Before Moscow, Europeans, they start school later than us. And so my lease had ended in August. And so even at 26 years old, I spent 2 months waiting for that next semester to start before I moved to Russia, living at home. I can think of countless times where I knew that I had that place to go. Yet, when teens are discharged to this Apple idea, or this, when we're not providing them with these really strong independent living services, I worry about what would have happened if I didn't have that to fall back on. I think my point's made. I won't say much more. Oh, this was my car. And I was going to do an analogy with the car, but I'm running out of time, so I won't do it. I think the point's made. Finally, improving legal advocacy. That was a big recommendation of all aspects of the case. And there's this general saying in the profession, raise the bar. What I would charge you to do is to raise your own bar as for the professionals that work in that capacity. And rather than draw any other analogies, I'll just put this quote up here from Ashley Rhodes Corder. She wrote an amazing book. I actually went to so when I went to buy this book, somebody had talked me into reading it, and I went to Barnes & Noble. I was looking everywhere. I was looking in the memoirs. I was looking in the nonfiction section. Finally went up and asked the person, and they were, where's 3 Little Words by Ashley Rhodes Corder? I've got to find this book. It's in the teen girls section. So. If I went through the teen girls section, but she talks about here, she was adopted out of foster care pretty late in her life as a teenager. And she ends with a Moliere quote here about that we're not only accountable for what we do, but what we don't do. And I think that's absolutely correct.
Can I just add a comment? Because she also says if they had just spent a fraction of what they spent on me and my brother in foster care on helping my mom.
Right. The family preservation.
The family preservation piece, because she talks about that too.
And this, Ashley Rhodes Corder, I think she's going to be speaking in Georgia at the Georgia Association of Counsel for Children. She's going to be giving a keynote here. And she's wise beyond her years. I mean, she's a very young girl. And she talks about kind of best practice ideas that just leave me in awe. I mean, she's got some really amazing ideas. She talks about that idea of family preservation. And for most of us, she grew up in foster care very close to here during our profession. I want to zip through in 5 minutes Permanency Composite 4. To me, Permanency Composite 3, I'm talking about the children in long-term foster care. That's received a lot of attention in the state of Georgia over the last few years. I think we have a couple of victory bells to ring there. We've done some really innovative work. Here's the new frontier. Here's where we're struggling. Placement stability is probably our best well-being measure. And I'll try and sell some of that now. Andy's already talked about the breakup of the 3 measures. We're looking at children that have only been in care for a year, children that have been in care for between a year and 2 years, and then children over 2 years. If you look at the performance from 2000 to 2010, here's placement stability. And while all the other 3 are doing...
All the others are going in the right direction.
This one looks like a slide
radically in the wrong direction.
Go down at the... Yeah, so that's got a big question mark. And more importantly, I'm not going to read all this, but the research suggests that it's really important. And there's plenty of research that even suggests that when a child moves from one placement to the next, that they can experience the same level of trauma as when they were removed from care. And what we tragically see sometimes is people with moves in the double digits and gets really, really large. It's not all the time, but it's a place that we really need some efforts. And I know I'm talking too fast for you guys to chime in, but please interrupt as I walk through this, as I move quicker. So we've had a couple of responses to try and improve placement stability. In 2007, we introduced House Bill 153. I didn't do it, but the state passed House Bill 153 to try and improve placement stability. What was the idea? Let's have the agency give advance notice of any anticipated place change to a certain group of people. Why would we give notice? Well, you can object and you can ask for a hearing to determine whether that move is going to be appropriate. There's a lot of details here that I'm not going to go in for. Of course, we've got our emergency health welfare exception. If this child's at risk of harm or harming the person in the placement, we're certainly not going to hold off for advance notice there. Okay, so ring the victory bell. We've got a good check on the system. We can find out whether why we're having so much placement instability. Our office did a survey, and I think I'm stealing these graphs without giving credit, but someone sitting very close to me put this survey together, sitting right here that introduced us earlier. Surveyed over 300 DFACS employees. And we asked them, in your experience, what were the primary reasons for frequent placement changes? And I've got the DFACS survey up here. We're going to look at some attorneys' responses, and we also surveyed the judges. There's nothing special about the results in this capacity as opposed to the other. It was by and large the same response. But what's interesting to me is that the primary reason, 90% of responses credited child's behavior with the reason for placement instability. The next closest, mental health challenges, not even half. Just around 40% mental health challenges. What about compliance with this advance notice requirement? We passed the law. How's it doing? Well, we talked to the DFACS folks. How often is notice requirement complied with in cases in which you've been involved? 39% most of the time, 26% sometimes, 10% rarely, 7% never, always 18%. So a mixed bag of response, but to me what's more alarming and where I can find a little more culpability is how often are hearings requested? Never, 45%, 36% rarely. So lest Isabel feels the need to defend anything here, I think there's just as much, if not more, culpability here. This hearings are never, I think our very often was 3% of responses, 6% somewhat often. And
well, it does speak to that passing a law doesn't change caseworker behavior or attorney's behavior or the court's behavior. So it's the value behind that, and often, frankly, we don't take time to build relationships and stay at the table long enough to understand what's really going on. And so the answer to this is not, wow, DFACS is just simply not conforming with the law, but how can we get the caseworkers to understand, change their behaviors by partnering? You saw that the cold case file is a tremendous partnering between the department and the judicial branch. Why? Because there was trust with the players.
And that's That's what I hear when I go around the state and talk about this law. I hear that DFACS isn't telling us when they're doing placement changes. And what I see here is that it doesn't matter if they would, because there's nothing happening anyway. So in any event, I want to look at some language here, some nice bleeding heart, terribly academic language. All possible efforts must be taken to prevent or abrupt or unnecessary replacement of the child. Determine if we can give anything to the placement resource to help prevent this disruption. There's that same idea if we could provide services to the child. We need to fully explore a change before any action is taken. And every move compounds the child's sense of loss. Essential that resolution be attempted first. So like I said, lots of national research on this. Who do we think wrote this nice bleeding heart language here?
It's all from one place.
Nice academic, some professor, ivory tower. This is your agency policy. So this here is agency policy. Now, why do I put agency policy up there? We've had a recent Michigan Supreme Court case that talks about reasonable efforts. What is reasonable efforts? The majority of the court found that reasonable efforts equals the agency and the court must comply with state law and court rules. 3 justices would add agency policy to that list. It didn't command a majority in Michigan, which is a good thing. We're not in Michigan. I would challenge someone to bring the same kind of argument to give reasonable efforts the teeth to allow us to hold accountable. Even though we don't have that case here, here's Judge Michael Key's language. You might have seen his presentation of reasonable efforts. He talks about unless it would be unreasonable to have the agency provide it, they better provide it. But one thing I see here is with the national research, with the local policy that is incredibly strong, with the passing of our objection to a placement move, providing advance notice, with this idea that we have to provide reasonable efforts not only to prevent removal, but to establish permanency for a child and to reunify the family. And with all this positive language, I have a hard time understanding why placement stability is such an issue and why we're not using that method or the law to comply with this. And so again, I would charge you that you've got a nice standard for what's reasonable here. And if we're seeing kind of just run-of-the-mill placement moves without a lot of exploration, that the reasonable efforts language can be an avenue or a vehicle by which we can attack this problem a little further. And like we said with the Cold Case Project, like we said with the Permanency Roundtables, hold each other accountable to try and improve outcomes for children. Placement stability is a big ticket item and one that we really need some attention on. So that's the homework. I'd like to see Georgia explore a case like this from a legal standpoint. And then likewise, I don't even think we need this kind of strong language. We have to we have to make reasonable efforts. And so what we're doing by moving these children around, I think can be connected to unreasonable reunifying families achieving permanency. We have -3 minutes for questions. We'll certainly stick around. We'll let I think we'll let the taping come to an end here and let folks venture out if they'd like to. But I know the 3 of us will be happy to stick around for a little while and answer questions. So with that, I'm going to turn it back over to Kirsten and